What's up, viewers, subscribers, and agents alike? It's your boy Light Lucifer and Prince coming to you, COVID-19ers, on this day lockdown 27,000. I wanted to come to you guys tonight because, as I said before in our previous videos, I have undeniable, irrefutable, evidentiary proof that this stuff works, and I'm using my own personal experience. I have something for you guys today, and it's going to be a treat for both sides. It's going to be sort of a defeat on the side of the establishment who watches this channel, because this is an actual legal proceeding that was recorded. And for the lay people, for the neophytes, so to speak, for the beginners in regards to this process, I'm going to show you how I actually use this in my own personal life with unrefutable, undeniable, transcriptural evidence. This is my evidentiary hearing transcript from when I had to tangle with the so-called authorities in the southeast in Chatham County. Now, this really took place, and this is my transcript, and I'm going to read it. I'm going to alter it a little bit because, for the safety of, identity purposes or whatever case would be, I'm not doing anything illegal. It's just being conscientious of what I'm doing. Certain things you just can't let your left hand know what your right hand's doing. All right? Now, part my mustache. I couldn't get to the barbershop. But without further ado, this is a transcript from the proceedings that were heard in the hearing and petition for habeas corpus in the above style case at Chatham County Courthouse, Savannah, Georgia, on the 3rd day of February 2020, before the Honorable Penny Friesman, Chief Judge, Superior Court, Eastern Judicial Circuit of Georgia. Now, one thing I want to also explain to people is, in regards to this procedure, I had been denied my evidentiary hearing 3 times in the space of 1 year. So I was actually supposed to be home a long time ago. But I'm going to show you why in this transcript evidence they denied me. You see what I'm saying? This is evidentiary. This is not conjecture. I was denied for the whole space of a year because what was laid on the transcript and what was put out there during this proceeding, obviously, they didn't want it, and it happened anyway. Here we go, people. Get you some popcorn, get you some, go get you some soda, and get ready to curl up, because this is it. This took place. This is my life. It says, good morning. I'm going to conceal my identity for good reason. Those who personally know me, you know me, but if you don't need to know me, then you don't need to know me. Good morning. This is the case of blank versus Warden Morales as the respondent. Is a habeas corpus, and the case number is SPCV blank 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 blank. Okay, Mr., which is myself, and Mr., it would appear that you're representing yourself. Is that correct? I respond in the affirmative. Yes, I am. It says, she's waiting, says, I'm waiting for you to get all set up. No, do what you need to do. I went a little too quickly here. I said, may I properly address the court, please? In a moment. I'm just trying to get the record set first. Also appearing on behalf of the respondent, who is defendant, I'll let you go ahead and make your entry of appearance. This is Attorney General. Yes, Your Honor. My name is, let me just keep her name out of it for someone tries to come up on me and try to sue me later on down the line. She's the representative here on behalf of the warden in the state of Georgia. Just really quickly, Judge, I like to correct the style, not necessarily change the party respondent. Jose Morales is no longer the warden at Coastal. It is Brooks Benton. We can correct the style. All right, Judge, thank you. But that doesn't change the case itself. Attorney General's response. No, Judge, it does not. But the Supreme Court would end up fixing it if it weren't fixed here, so I just figured I'd go ahead and write it and knock it out. The court says, all right, thank you. Mr., which is myself, this is your petition for habeas. Usually what I would do is go through the petition and get you to elaborate on the different things that I see here in the petition. Would that work for you? Yes, ma'am. All right. It would appear, give me 1 minute. I'm going to go down the actual grounds, and it says failure of the arresting officer to adequately Mirandize me. It is not your handwriting is that is bad, it's just small. So I'm trying to read it all, thus resulting in the promulgation of added charges, something under Amendment 5 of the Constitution of the United States of America, which is what the first ground was in my petition in regards to the application for habeas corpus. And it says you place some supporting facts here talking about how the arresting officer had failed to Mirandize you. Do you have anything else that, first of all, let me get everyone, if you're going to testify, let me also get you to raise your right hand, and get sworn in. The large portion of this was X'd out for good reason from the court clerk, because I swear myself in a different way than most people do. But now that everyone was sworn in, the court says, now let's be seated. So what I'm going to do, the proceeding proceeds forward, says what I'm going to do in this hope is that you will add a little structure for your help and sort of get out what you're going to have a chance for you to say everything that you wish to say. And then, of course, if you have anything more to add, you're certainly welcome to do so as well. But first thing has to do with the failure of Mirandize versus anything you wish to testify about that. My response in the affirmative, yes. Again, it says I am going to properly address the court so that the record properly reflects who I am and what my status is before the court. This is vitally important. It says I like to say that my name is Lord blank blank blank, power of attorney in fact, pro se representative for blank blank blank, corporate fiction and all derivatives thereof. Now, in regards to this statement I'm going to make, they're not incriminating statements. They're supporting statements to solidify the relief requested in the petition, because particularly on the day of May 1st, 2018, the arresting officer failed to Mirandize me prior to my arrest, which was true, thereby resulting in added charges in violation of due process clause of the 5th Amendment of the Constitution of the United States. Such claim is supported by statements attached herewith, which I presented in open court and presented this before a judge, a judicial officer. It says, now when I made the claim in the first ground, it was on the day of May 1st. I was arrested for simply a simple battery. And upon being arrested, I was transported to the county jail, and the arresting officer charged me with 2 counts of obstruction, which resulted in my felony incarceration. And 1 count of tampering with government property, which was interference with a locked unit inside the Henry County Jail, which was ridiculous. However, upon the day of May 2nd, the court notified me that I had been charged for an accusation on behalf of the Sheriff's Department. And these added charges that were originally upgraded to felony charges, which resulted in my current incarceration, because this is the truth. This is what took place. So the reason I alleged the first ground failed to Mirandize is because the United States was a case of Miranda versus Arizona with the purpose of the arresting officers as far as compulsory evidence being entered in regards to a person's criminal prosecution. They are to be informed first and foremost of their rights, which I wasn't. And on that ground, I'll rest there. That's it. I rest on that ground. The court says, all right. Now this is where things get a little bit more litigious, get a little bit more in-depth. It says, let's move on. It says that magistrate's court never established subject matter jurisdiction in regards to the commercial charges in violation of due process. It says that may be a provision of Amendment 605 of the Constitution for the United States. Anything you care to add to that? Yes, indeed. Again, as I said earlier, on May 2nd, 2018, this is my response. The magistrate court bounded over the case by waiver in direct violation of due process in Superior Court. The case aforementioned, subject matter jurisdiction cannot be conferred to a court by a contract. Such evidence is substantiated by a waiver attached and admitted. The reason I stated in the ground that the court assumed jurisdiction over the subject matter of the case was that I was never properly informed by the interests of the case before being bound over in magistrate court that these charges indeed themselves were actually going to be, as opposed to an institutional charge, that they were actually going to be public charges. So the subject matter jurisdiction was not actually conferred by consent of myself, but actually by the Public Defender's Office in Henry County. Please, let me take a sip of water on that one. I never hired these people. They were appointed. I never hired them at all, and I refused their representation every step along the way. I myself was never really fully informed of the full disclosure of the actual procedure in regards to that waiver. That was actually signed without prejudice, which I attached also to the case, which is admitted into evidence as an exhibit that was attached to the original application. The court, all right, thank you. The third says commercial fraud by using my trademark copyrighted property to hold me as surety and guarantor for charges lodged against the corporation in violation of Amendment 5. So as I say in my response in the affirmative, So the record properly reflects that ground. Let me allow myself to state commercial fraud in regard to the public officers herein mentioned by using my trademark copyrighted property to hold me as surety and guarantor for the charges against the corporation in violation of Amendment 5. Before I proceed, let me put on the record to the court. This is what I said. I would like to say that my name has been trademark copyrighted in regards to the state Secretary of State. It is on public record in the county of blank under agenda number blank 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 filed March 12th blank. So all public officers and officials here today are notified that my name is my private property. And any document that purports to use my name is chargeable per user and issuer in the amount to some certain $1,000 per form and per issue per user, any past, present, or future use. Place them on notice. Hey, that name costs now, and it's open on court record. Now, proceeding further thus. It says, on the day of October 3rd, 2018, Judge Trey Pipkin committed the act of commercial fraud by using a falsified constructive trust in Sleeges Corporation by levying commercial charges against my Sister KV Association without filing a uniform commercial code financing statement. Such evidence is attached herewith. I attached with the original application a copy, and it is being admitted into evidence, of my trademark copyright, my UCC1 financing statement, and also an affidavit of specific negative averment, along with my power of attorney in fact. In short, to simplify this, the act of commercial fraud is used whenever an official uses false or misleading representations in order to do something that is legally inadmissible by the practice of law. In other words, that they wish to charge me, the natural person, with charges that I should have been charged in my proper context and name, not in the name of a corporate person or persona, such as a corporation, which is a fictional entity. It is right here to say that since I filed these affidavits in March blank, and boom, she cut me off. She said I had to ask, what is your proper name? My response, my proper name is every letter initially capitalized, every letter after their lowercase, which is according to what the record is. In other words, if you look at the actual petition and the actual accusation that was filed in Henry County on the day of, let me see, give me a second. The petition was filed in December and purports to undertake myself, the natural person, as a corporate fictional entity to be held as surety and to be held as guarantor for charges lodged against the fiction. In other words, this is a secure transaction with the specific intent for the state of Georgia to hold me as a liable entity in regards to charges lodged against the fiction, which in regards to itself is actually an illegal action. All governments and all counties in regards to any state are constitutors. Therefore, they are responsible for undertaking all illegal debts, all charges, and all public and private debts, and therefore they are to hold themselves liable by oath of office. All of that has been violated in regards to due process because the transfer was by contract and it wasn't by due process of law. It's adjudicated by a jury trial. And I rest my ground. She cut me off on that one because it got heavier and got heavier in that area. It got heavy in there. He says, okay, all right, thank you. It would appear that, foreground. Judgment entered against my trust association without court having adequate subject matter jurisdiction over the commercial charges in violation of the Fifth Amendment of the Constitution. Anything further to add? I say, all right, let me further add this. Let me simplify this because I know that these grounds have been versed in legalese, which I'm sure that many people here are well versed in as opposed to actual certification to practice law. Let me simplify it. In other words, the court did not have subject matter jurisdiction over me, the natural person. In other words, I filed an affidavit in the month of July with the district attorney's office. I stated particularly in letter format that I myself would not be obligated to hold myself liable for charges against a fictional entity. However, no rebuttal, no response, nor has any controversy of the matter come forth from the district attorney's office. And that day, October 3rd, I then myself made the courts aware that I would also not be held and made liable in the court by appointment of attorney in regards to the public defender's office then coercing into accepting the plea by taking the charges that were actually in one case and lodging them on the opposite case and merging them together. Now, in short, let me go forward. It says, because this is a lot of pages and I'm just going to simplify the video to get to a very key point in this entire transcript. I said in court, specific negative averment, Federal Rule Procedure 9A states particularly that whenever any individual moves in any civil matter or any public matter to assert the proper persona, sui juris, then they allege the capacity in which to sue and be sued. So in short, let me clarify for the record, I am not a corporate fictional entity. I am not a corporation. I'm a sovereign free-born inhabitant in the land, and I am a natural person. I am not a corporate personage. And all these affidavits have been presented to the Attorney General's office, and no rebuttal has been coming forth since. I granted a period over 10 days for rebuttal, and it has been a year. And I have received no response from the Attorney General's office in regards to that. So they consent by assent to this factual declaration, irrespective of their argument if they so wish to move forward today. Thank you. Let's skip over her argument for better usage, because she just went over a whole lot of nothing. And I'm going to go into my admittment to my records in regards to my proceeding. One of the key things is this: pay attention to the list. You'll follow me in these videos, because yes, they do work in court. Attached therewith to my original application is a UCC1 financing statement with the proper name reflected of myself as a secure party and all other collateral therewith claimed there on Section 4. There is also a Form 56 concerning notice of fiduciary relationship, otherwise placing public officials on notice that I terminated my fiduciary relationship with the United States Corporation circa 1871. It's date stamped. Also to mention, I have attached a Form W8BEN, Certificate of Foreign Status, withholding of beneficial owner for United States tax withholding. In other words, it is also a public declaration that I myself am not a U.S. 14th Amendment citizen. Attached after that is a Social Security Administration request for withdrawal of application, which proves that I had, beyond a shadow of doubt, filed on public notice with the Social Security Administration my actual removal of myself from the Social Security Administration. And I am not a corporation under federal law. All of supporting particulars in paragraph, I will not go into there. I will not go into detail with regards to that, because the official who wishes to oppose that in the adversarial stance may do so within 30 days. Attached after that is Public Policy House Joint Resolution 192 passed June 5th, 1933, which in and of itself is a public declaration which proves that the government themselves, the for-profit private entity, is responsible for all public interests and government debts, which should be lodged against the American public, and they are responsible for the obligation therewith. After that is specific negative averment, denial of corporation's existence, Federal Rules Civil Procedure 9A, which is an affidavit which particularly states that I am not a corporation, and that affidavit can be rebutted within 10 days if the Attorney General's office so wishes to do so. The following documentation is trademark copyright, as I mentioned earlier, which has been placed on public record, and it states particularly everything I stated earlier. Reservation of rights, UCC 1308.4, which says that I claim my reservation of rights, I claim common law jurisdiction, I do not consent to this commercial matter, and I waive the benefits. That in and of itself has been admitted into evidence. Let's go further. Let me also say this. I just wanted to also place that on record, that I also did move the court to grant summary judgment based upon the Attorney General's office failing to state a claim upon which relief may be granted due to consent by assent. Let's get to the most important part of this video, because I want to put this in the video because I want it to be known that amongst all the objections in regards to this proceeding, the judge sided with me on my evidence. And I know that this is going to be very hard for some agents to believe that. How did he do that? How did he do that? Yes, the judge sided with me. I have concrete proof. Here it is. Let's go. All right. This is what the court said, and this is where this all falls into my favor. And trust me, agents, they're going to be very mad because what I'm saying is true. It's on paper. It says, the court, all right, let me begin this too, because I have failed to do this in the beginning. I have plaintiff's number 1 here. Right now I have plaintiff's exhibit number 1 up here. Any objection? Ask the Attorney General. Says, Judge, I'm not sure how it's relevant to his claims. I understand that what he's saying is disputing the service, but dispute about the service isn't relevant to his claims. And based upon that, Judge, I would object on the basis of relevance. The judge says, all right, noted for the record, I'm going to admit plaintiff's number 1 over objected. Now, you have in your hand exhibits. What are those numbers? Let's go further. She also says, I stated all of the information. She asked the judge also, exhibit number 2, Your Honor, that was tendered and admitted into respondents number 4, or pardon me, number 5. Respondents exhibit number 5 based on that, Judge, I don't see the blank. It would just be redundant and cumulative. But otherwise, you have no objection. Otherwise, no objection. Let's go ahead and enter in plaintiff's number 2 then. All right. No objection for plaintiff's 3, other than that, for what it's worth, just to put it on the record, I suppose the fraud written across it, we would object to that because it's an alteration to the document. Otherwise, the document we have no objection to. The judge says, all right, so plaintiff's number 3 is admitted without objection except to the handwriting on it. Next one, it will be admitted, she says, it will be admitted for the value it may have. Plaintiff's number 3. Then plaintiff's, judge, is the UCC finance statement, which is number 4. I would object to that as to relevance again, Judge. The claim that it purports to go to, it just doesn't state a claim in habeas corpus. This is what the judge said. Plaintiff's 4, then I'm going to go ahead and admit over objection. Key phrase, for the value it may have. I think relevancy can be a difficult one because so much can be relevant, and I'm going to just allow it in at this point. That was number 4. She says, my trademark copyright, which is number 5. Plaintiff's number 5 for several pages. Along your honor, objection as to relevance, number 5. This is what the judge says. Then I'm going to admit it over objection for the value that it may have. Then again, as to any objection as to number 6, relevance, because it has to do with federal Civil Procedure 9A. Obviously, Judge, we're not in federal court, so it's not relevant. The judge says, number 6, I'm going to admit it over objection for the value that it may have. Finally, Judge, objection to plaintiff's number 7. And the same for plaintiff's exhibit number 7. So plaintiffs 1 through 7 are admitted, and I believe I have admitted respondents 1 through 5. Yes, Your Honor. Here we go. In the discussion. So all of the documentation that I talk about on my channel, I actually admitted into court, and a judicial officer actually admitted them into evidence. And I didn't want to bore you with going through the entire transcript, but this is recorded. This is certified copy. This is proven. That's transcript. I use this stuff. Okay, people? I use this stuff. See, I'm not a YouTube guru. I actually practice what I preach. And the reason why I wanted to put that transcript on evidence is so you get more insight into where I was and what I've been dealing with. Because, hey, something small turned into something major. And then I got denied on behalf of the processors because it's what I use. And the people that were supposed to be in these offices don't want this information to come out. I use this stuff, people. Trust me. I admitted in open court. And as you can clearly see, the judge admitted all my evidence over the Attorney General's evidence because they didn't have any. They didn't even respond to the case till up to a year later in regards to a 21-day stipulation for habeas corpus procedures anywhere in the United States. You have, within 30 days, you're supposed to send a response and a return and answer. They didn't respond and return an answer until January the next year. And now you see why. It is what it is, people. This is my life. It's what I do. You know? Like and subscribe. And agents, I know you're going to be mad. Because guess what? This is legal. This is proven. This is on record. Stay tuned, y'all. Stay tuned for the next episode. Peace. Love y'all. And agents, you know what it is.